if the debt obligation has already been paid in the trust, why is the bank coming in and taking the house? There is no like when you wreck your car and it's totaled, the insurance company has salvage rights over the property. But in real estate, if they have a credit default swap insurance built into your note, you're unaware of it. Why are they getting paid and they're coming in and taking the house?
Exactly, it's double dipping.
That is totally
because it would set a dangerous precedent if they didn't. Because like all you folks already understand, it's very basic and simple. You took out a $500,000 note, correct?
No. Well,
you already took out a $500,000 note. Okay, they already made $10 million on it. Okay, so if you don't pay back that $500,000, they really don't care. They already made their money, right? We all understand that concept of how they fractionally reserved it and how they monetized your note.
Yeah, but the more interesting aspect is it's not money you're talking about.
Okay, it's credit.
Yes, because if you go with the definition of money out of Black's law, it's gold or silver. And
money is what a medium of exchange between which two parties believe has value.
Okay, let me read it to you right out of Black's law.
That's legalese. That's legalese. I talk law.
This is law. Black's law forth is from a case. Money, in usual and ordinary acceptation, it means gold, silver, or paper money used as a circulating medium of exchange and does not embrace notes, bonds, evidences of debt, or other personal or real estate. From Lane versus Raley, 280 Kentucky, 319.
Okay, so that's somebody's opinion in Kentucky from however many years ago.
Okay, but
money is just a medium of exchange in which two people have value. Like if you do some work.
Let Lentz finish his thought.
All right, and then if you look at the definition of note in Black's law on page 1210, note is a unilateral instrument containing an express and absolute promise of the signer to pay to a specified person or order or bearer a definite sum of money at a specified time. So if it does not embrace notes and you have a Federal Reserve note, then that's not money.
He didn't buy the house with a Federal Reserve note. He bought it with his note.
Hey, you got a negotiable instrument, which is a worthless piece of paper.
So he bought it with a worthless piece of paper, his note? So he committed fraud?
Technically, his note is a promise to pay, but his note is a valid note, isn't it?
I thought you said it wasn't money.
It may or may not be. We don't know until we can actually have proof that there is an actual chain that followed after I signed.
You said it had to be gold and silver.
It's a promise. A note is a promise to pay a definite sum of money.
Okay, so he wrote a note. So he was going to pay in gold and silver. Has he ever paid in gold and silver on his note?
No, never.
He didn't receive anything of value, so why would he owe anything?
The house. The bank was just a broker between him and the architect.
The bank didn't give him a house.
But that's right. What happened was the architect built a house, and the banker is just a broker. The bank, a riverbank, just receives deposits. It doesn't produce. A riverbank doesn't produce anything. It's just the receiver of deposits. So when the architect wanted to build a house, they went to the bank for a loan. So the butcher, the picker, and the candlestick maker in town deposited their money into the bank. The architect borrowed that money from the butcher, the baker, and the candlestick maker. He built the house.
How it works. It's the money from the thin air, as you admitted.
Yeah. No. You get it from the principal. They get it from the United States Treasury Department. They're an instrumentality of the United States Treasury. That's the bank. They're just a broker.
The United States Treasury went out of business in 1921.
That's what you believe.
All right. Well, we're getting off the subject. Let's get back to
I believe they don't
title
follow
action.
the Constitution when they say nothing but gold and silver. And there's nothing that authorizes them to break that.
So he didn't buy with gold and silver though either. So he's in committing fraud too.
And if the bank had loaned you gold and silver, then you would owe them gold and silver back. But they gave you a piece of paper, and you gave them a piece of paper, and that's an equal exchange. And the bank
that's called common law. That's the law that's common between your people. If it's wampum, you trade in wampum. If that's the common belief and that's the common practice of a people. That's the common law. They trade in green notes.
The Constitution allows only gold and silver. There's nothing, you can't argue the Constitution makes anything but gold and silver and does not allow for bills of credit.
The Constitution only applies to United States citizens.
And how would you use that in court when you're dealing with a quiet title action or I mean, that's another argument I guess you can use.
The argument is you never received anything of value.
Yeah.
No.
And if you look at the Credit River decision, that's exactly what they ruled on.
Right. You have that.
And the Credit River
Go ahead.
was overturned by the appellate court, wasn't it?
I don't know. Was it?
It was. However, the Credit River decision stated right in there when the bank took them to court that it was a common law action, which would apply to under the 7th Amendment. A common law action over $20 can't be reversed except by a court of record.
Or according to the rules of the common law.
Yeah, and the appellate court that overruled it wasn't operating according to the rules of common law.
Well, they believe that was the common practice in South Dakota.
So there's a huge difference between common law and what they believe.
Well, common law is whatever's common to the people in that society, that district, at that period of time. English.
All right, let's look. We need to wind this down. We're getting close to the 2-hour mark. We still have 2 people in line to ask questions. Max,